Hello, everybody. I'm continuing about recklessness in criminal law. Sorry, I was interrupted a moment ago. Anyway, so as I was saying, that knowing that there's a risk doesn't always require someone to think about it as such. So, anyway, that's true for crimes of malice. And malicious wounding is the key one. That's as per Section 20 of the Offences Against the Person Act. So the redoubtable Professor Kenny, that guy was writing before the First World War, he'd said a defendant had to foresee that the risk of injury was there. We would probably talk about being aware of the risk of injury these days. So we can be aware of something without thinking about it as such, just somewhere in the back of your mind. Parker 1977 is a case in point. Here the defendant was in a foul mood and he slammed down the telephone and the public phone booth when he finished his call, and that broke the phone. So he's fined for damage. So he appealed. The Court of Appeal said no, the fine was right. He was rightfully convicted because the defendant didn't think about damaging the phone, but he was closing his mind to the obvious, as they say. Everybody knows that if you slam down the receiver, that can damage the phone. So the Lord Chief Justice was Lord Lane at the time, and he said, a man is reckless in the sense required when he carried out a deliberate act, closing his mind to the obvious fact there is some risk of damage resulting from that act, but nevertheless continuing the performance of that act. So this is applicable to those who close their mind to the blatant. But how about very young people, those with severe learning difficulties? They wouldn't know about these risks in the first place. So are they to be held to be reckless? Well, in Stevenson 1979, there was this homeless itinerant, and he started a fire in a haystack to keep himself warm. Brilliant idea. So the haystack was burnt to a cinder. He was charged with criminal damage. So this chap was a schizophrenic. An expert advice said that he might not be able to understand risk, to foresee danger in the same way that most people could. So the trial judge told the jury that they could still find the defendant guilty if they believed he closed his mind to the fact that starting a fire could burn the haystack to smithereens. The judge said, all kinds of reasons make a man close his mind to the obvious fact, among them is schizophrenia. So the jury found him guilty. So the defendant appealed. So apart from closing your mind to that sort of recklessness, there's another qualification about the need for the prosecution to prove conscious foresight. It might be that someone was not aware of something because of voluntary intoxication, as in getting drunk or taking drugs. Brady 2006 is a case about this. The defendant was in a crapulous state. He climbed on railings in a nightclub and he fell onto the dance floor, and there he injured a victim who was dancing below. So the defendant was charged with malicious infliction of grievous bodily harm under Section 20 of the Offences Against the Person Act. So the judge said it's about recklessness. Where there is no issue of intoxication, the test requires the defendant should be aware of the risk and go on to take it, the risk being injury. The judge then talked about recklessness if someone was intoxicated voluntarily. If the defendant had been sober and in good mental shape, he would have realised that some injury might result from his actions in what he was doing in the condition he was in that night. So the Court of Appeal said that that is right. So the man was convicted. So if the only reason you're not aware of the risk is because you're drunk, well, that's your stupid fault. This is voluntary intoxication. Involuntary intoxication is different. If you were taking medicine that you were supposed to take, and that caused some derangement of mind or befogged your mind, impaired your judgment, then that's different. You can't understand these risks. You don't realise you're imperiling people, and that's not your fault. So in that case, you'd be not guilty. So a person is reckless if they know they're taking a risk without good reason, or if they're not aware of risk only because they're drunk, but they would have been aware had they not been drunk. Okay, so the risk has got to be unreasonable for this to operate. And we take risks all the time. Every time you play a sport, contact sport, you can get hurt. Every time you step into a car, in a car crash, you cycle, you go on holiday, you get on a plane, we take risks. So we can't really live without risk, but these are acceptable low-level risks. We've got to talk about unjustifiable risks. So Lord Lane and Stevenson talked about when risks are justifiable, when they're not. Forgive me. Anyway, he said, a man is reckless when he carries out a deliberate act, appreciate that there is risk that damage to property may result from his act. It is, however, not the taking of every risk which could properly be classed as reckless. The risk must be one which is in all circumstances unreasonable for him to take. Whether the risk is reasonable or not depends upon, in particular, the degree of risk involved, the type and amount of harm that could occur if the risk materializes, and the social utility the risk is taking. Stated as a loose equation, the more likely and dangerous the risk is taken, the greater the social utility of the risk must be to offset it. Someone who drives his car at 60 miles an hour may well be driving recklessly if he did so because he was late home for dinner. However, the jury may take other views if the person drives so fast because his daughter's appendix has burst and she's bleeding to death and they're taken to a hospital. The risk here is arguably offset by the social utility of the risk-taking. To help you decide these matters for yourself, ask yourself honestly, is the risk I might have taken myself in the circumstances? So there's also an objective form of recklessness to consider. In the late 20th century, recklessness was considered to be objective. They didn't have to prove that the defendant foresaw that harm could result from the act he was committing. It was sufficient that he should have foreseen it, even if he didn't actually foresee it. Caldwell, 1982, is a key case here. The defendant was inebriated and he set fire to a hotel. This was reckless arson. He said because he was drunk he didn't know what he was doing and the consequences. So this argument had worked in Stevenson. But the reason the defendant was not aware was due to drunkenness. But in Stevenson it was because of his lack of mental capacity. Under ordinary circumstances, not to do with alcohol. The defendant was found guilty in Caldwell. The judge said that the jury, his lack of awareness was no defence because it was self-induced intoxication. The Court of Appeal, they upheld the conviction. When they went to the House of Lords, and the House of Lords, they denied the appeal, but they gave a different ground. They said it didn't matter whether or not he was intoxicated, but that would not negate the fault, because if the person thought I don't think what I'm doing is dangerous because I'm drunk. It's about what reasonable people would have done so. The failure to think here was called manifested fault. So Lord Diplock said this is the direction to be given to juries in this case about recklessness and criminal damage. This is what Lord Diplock said. If he does an act which in fact creates a risk, an obvious risk that property will be destroyed or damaged, and when he does that act, he either has not given any thought to the possibility of there being such a risk, or has recognised there is some risk involved and has nevertheless gone on to do it. So that's the end of the quotation. The vital thing here is that the jury tells it. They can find the person guilty of recklessness and criminal damage, even though the defendant didn't think about the damage, so long as the risk was blatant. And that means it's a reasonable person would have seen that there was a risk. That's the standard definition these days in crimes involving recklessness, unless there's a crime such as assault or malicious wounding. Now, oddly, these require awareness of the danger of causing harm, assault and malicious wounding. Spratt, 1990, is a case about that. GNR was a case from 2003. There were two boys aged 11 and 12, as they're just known as by their initials. So this is a fire. They were away from home without parental superintendence. They decided to camp in the back of a shop, and in the wee hours of the morning, they had the bright idea of setting a fire in a dustbin to warm themselves. But the fire raged out of control, and the shop was burnt to the ground. The boys were charged with arson. So the House of Lords said that the Caldwell case of recklessness wouldn't be fair for children at that age. They couldn't be held to the same standards as adults. They don't have such foresight. A risk which is blatant to an adult wouldn't be blatant to a child. Now, the House of Lords, they could have maintained the law as it was. They could have adjusted the law to make this recklessness test sensitive to children, or they could have returned the law to the situation prior to Caldwell, and they went for that last option. They said Caldwell is wrong. Okay, so then we'll have a little look at negligence. So in negligence, it's vital here to tell apart negligence and recklessness, because remember, it's all to do with subjective fault, right? So recklessness is subjective fault. Negligence is objective fault. Negligence doesn't have to. There doesn't be any awareness of risk. All cases of recklessness are also cases of negligence. So recklessness is negligence with an extra fault, and that is you're aware of the risk that you're taking. But not all cases of negligence are also recklessness, because negligence does not require there to be any awareness of a risk being run. So the two fault elements blur into each other in the case of closed mind recklessness, because the fault element here can be proven without showing that there's any conscious awareness, so long as the risk would be blatant to an ordinary person. Okay, so if the defendant is negligent, he may have been reckless if the jury thinks that the risk he's created is so obvious that he must have closed his mind to it. So negligence calls a broader field of wrongdoing than recklessness. But anyway, if you describe someone's conduct, it's describing someone's behaviour, not their state of mind. There are many ways that someone's behaviour could be wrong, but other than them deliberately creating a danger. The Law Commission, they defined negligence in a way that made that blatant. So where a person fails to exercise reasonable skill, care, or foresight, as a reasonable man in this situation would do, that was the Law Commission's working paper from 1970. They're crimes of subjective fault, and they go up in stages to show with how strong your wish was to actually cause harm to people. So murder is the gravest because you deliberately killed someone. Reckless manslaughter is less. You did something dangerous, not wishing to kill someone, but willing to take that risk that someone would be killed. So, so negligence, that's a form of objective fault, and that's this is part of this scale of wrongdoing. There are various levels of negligence. At the top, there's gross negligence. So there's a great fault element here, gross negligence, manslaughter. To be guilty of this, the prosecution needs to show more than the defendant didn't exercise such care, skill, or foresight as a reasonable man in the situation would exercise. Gross negligence, manslaughter. They need to show that the failure that led to the victim's death was a very high level of negligence. It can't be minor negligence or quite serious negligence. It has to be gross negligence. There are other crimes, for instance, causing death by dangerous driving. There's extra negligence here, beyond ordinary careless driving. Dangerous driving is worse than careless driving. There's also causing death by dangerous driving. Careless driving crosses over into dangerous driving when it falls not below but far below the requisite standard. Okay, that's section 2A of the Road Traffic Act 1988. So it's about causing an obvious danger. Anyway, there are lots of other crimes with an aspect of negligence. The blatant one is rape. So until this Passing Sexual Offences Act 2003, the defendant would not be liable if you really believed that the victim was consenting. There's a new fault element there. There's negligence, objective fault. So the defendant will be able to avoid liability for intercourse with the unconsenting, only if his belief that the victim was consenting was based on a reasonable ground. So the negligence aspect is included in things which are otherwise strict liability crimes. So they incorporated no negligence or due diligence defence. For instance, in Section 28 of the Misuse of Drugs Act 1971, a person has a defence to what is otherwise a strict liability crime of possessing controlled substances if he can prove they didn't believe or suspect or had no reason to suspect that the substance was a controlled substance. So notice it's upending the usual burden of proof. It's the defence, not the prosecution, that has to do the proving of that. Had no reason to believe that it was an illegal substance. The justification of this is because it's a strict liability offence, and therefore it's difficult to avoid liability there. Okay, so I hope you enjoyed this. So please donate to me on PayPal, georgecallahan79@gmail.com. Callahan is all small letters, CALLAGHAN. Bye bye.